Okay, good afternoon. I don't have a PowerPoint presentation, I'm just going to chat to you.
Okay.
And hi, good afternoon. So this is a work in progress, so I welcome your feedback on this. And the project I'm working on is called Human Right and Natural Right to Intellectual Property, or I was thinking of calling it Rethinking Human Rights to Intellectual Property. And I'll just tell you how I got started on this project is because I started thinking about corporations claiming human rights to intellectual property, which is something that was done by Anheuser-Busch, the owner of the Budweiser trademark, and the claim that there's a human right to intellectual property was also recently confirmed by the European Court of Human Rights in the Pirate Bay case. So one was with respect to trademarks, the other was with respect to copyright. So for this paper, I'm not arguing that we should have a human right to intellectual property. I'm not entering into the debate between utilitarianism and natural rights. My only goal with this particular project is to look at how does the human rights framework for intellectual property fit into the debate, really. Okay, so let me just tell you how I got there. Basically, the scholars that argue for human right to intellectual property, or some aspect of intellectual property being a human right, suggest that it's going to create a more balanced system. Okay? Yet at the same time, we have scholars who use natural rights generally to argue for more expansive intellectual property protections, and I thought this was an interesting contrast that we had going on here. So we have the human rights people saying we're going to get more balance, and the natural rights people using natural rights theories to justify more expansive intellectual property protections. And so basically my thought was maybe human right to IP is going to cause us some problems. And I saw that the human rights framework could be used in two different ways. One is to promote a human right to intellectual property, which is where I had some concerns. And the other one was to use human rights to limit intellectual property rights, so that if IP rights conflicted with human rights, we'd say, okay, maybe we need to look at the human rights concerns. So the paper really is focused on the first part, which is about using intellectual property or claiming human rights to intellectual property protections. Okay, so how is it that, my question here is, how is it that we have the natural rights folks using, for the most part, natural rights to justify stronger protections or more expansive protections, and the human rights people reaching the opposite conclusion? What is there that human rights does, if anything, that's different from natural rights? So that's the question that I have for this project, right? Before I get into that though, let me just tell you a little bit more about the human rights, just tell you in general the couple points I want to make about human rights. So one is that human rights, I would argue that human rights are natural rights. Some might contest this and say, human rights are not natural rights, but I think that's really the minority position. I think it's generally understood that human rights are the rights that you enjoy by virtue of being human, right? Sort of your God-given entitlements. And that the human rights instruments reflect a recognition of these rights. So I'm starting from the position that the human rights framework is a natural rights framework. Now, there are a couple of different ways that one can make an argument that there is a human right to intellectual property. So there's under the Universal Declaration of Human Rights, which is a declaration. It's part of customary international law, so it's part of just the law globally that everyone accepts. So under the Universal Declaration of Human Rights, we have Article 27.2, and there's similar language in the International Covenant on Economic, Social, and Cultural Rights. And I'll just read that language to you. So 27.2 says that everyone has the right to the moral and material interests arising from any scientific, literary, or artistic production of which he is the author. Okay? So you have the right to moral and material interests arising from any literary, artistic, or scientific production of which you're the author, and the argument goes that this parallels copyright, possibly, or patent. Okay, so maybe there's some intersection between copyright law and patent law and what we have as human rights obligations. And Then there's also the right to property. So the Universal Declaration of Human Rights recognizes a right to property and the right not to be deprived thereof, except in accordance with natural justice. So there are two ways in which one can make claims that there is some sort of human right to intellectual property. And so again, I'm not saying that I think that it's ideal to have a human right to intellectual property. The concern that arises is whether or not it's going to lead to more entrenched rights. And I've actually, in this project, I was challenging myself to find what is it that is different, right? Does it really just take us to the position of having stronger rights? And I've reached the conclusion, I think, that human rights does something a little bit different from what's being done with the natural rights philosophies in the US. So let me just speak briefly about the natural rights approach. And I'll just say that the human rights philosophies, modern human rights law, is generally understood to be based on John Locke. When people talk about natural rights, intellectual property, they refer a lot to John Locke. So we're always talking about John Locke, and I'm not doing my own analysis of John Locke. I'm just looking at what are the different analyses we have of Lockean theory. Okay, so again, it's just this whole idea, right? So Justin Hughes, for instance, writing about these rights being rights that are derived from a source other than law, right? So you have the whole idea that they're natural rights we have, right? The law sort of recognizes them but does not create them, okay? So people like Hughes and Mossoff, you know, the standard line is we have this Lockean labor theory. You see people like Mossoff, for instance, looking at patent history and saying it's not a privilege, it's actually a right, and therefore these more expansive protections are justified. So that, I would say, is sort of the more standard approach for natural rights. Now, we do have some natural rights theorists who argue that natural rights will lead to a more moderated approach. So, for instance, I looked at Yen, for instance, who argues against utilitarianism because he thinks it will not lead to a great result, and argues for natural rights as leading to more balance and moderation. And then you have also Gordon's piece. And I think Gordon's piece is the one of the pieces that's more closely in alignment with what human rights law might do. But I think there's still a bit of a distinction there. So Gordon, you know, basically she argues that you cannot harm the public, right? So you just use the sort of no harm theory to create a limitation on intellectual property rights, right? Her argument being that Lockean theory does not permit you to harm others, therefore you're not going to have property rights that are too strong. Okay, so her argument is primarily a property argument, right? So what does your justification for your property, does it cause harm to the public? Mergis, I thought, was also quite interesting because he now talks about the theoretical justifications, natural rights justifications for focusing on the individual first, with the community having a secondary interest. So society has an interest but not a co-equal right. And I think this is one area where human rights is distinct from some of the natural rights theories. Okay, so the idea perhaps of community. So if you look at the natural rights scholarship, right, the idea is that you, the laborer, you, the creator, have this right to your property, and the focus is on the individual, right? With human rights, it seems like it takes it further insofar as it's about the individual having a right as part of the community. So in human rights, there's language in the UDA, in the Universal Declaration, for instance, talking about everyone having duties to the community, in which alone the free and full development of his personality is possible. So the idea of community and having an obligation to the community, contributing to the general welfare of the democratic society. So I think this is one of the possible distinctions with human rights. And then, you know, you might say that the natural rights theorists, the natural rights IP theorists also recognize community, but that community tends to be focused on property, right? So Mergis, for instance, talks about the community of owners, right, where each person has to respect the property of the other. So we're communities, we're all communities of owners. So it's not just the concept of community, but I think the nature of the community that we're talking about is also different in the human rights context, because human rights considers all the rights and not just the property interests. So it strikes me that maybe the difference with human rights is that the natural rights IP theorists have been focused heavily on the property interest and on justifying the property interest. And even if you take a natural rights approach, and human rights is a natural rights approach, if you look at human rights, we're thinking about all the different human rights that have to be taken into consideration. And so not just does my property affect your access to what might be community property, right? So one of the theorists talks about sort of the community having a property interest versus the individual property interest. If you look in the human rights context, then you might say, how does your property interest affect my right to health? How does your property interest affect my right to food? How does your property interest affect my right to expression? So, so it seems to me that maybe human rights, at the end of the day, does two things differently from the natural rights IP philosophies that we've seen so far. So I think possibly just the element of community, and then also looking at the rights in the broader context, right? So that you have the nature of the community is different, and the whole idea that you have to consider all the rights, all human rights, and this comes from the idea that all human rights are indivisible, they're interdependent, and they're inalienable, right? So we all have human rights, and so if we, I cannot use my human rights to harm you in any way, not just your property interest, but also your other interests. So then I think it can make a difference insofar as if you're talking about somebody making a claim that they have a right to food, right? So for instance, thinking about the farmers, the Monsanto type case, and the patents, if we focus only on the property conversation, farmers might not really have a claim, right? But if you look at it from the human rights perspective, then maybe they have a stronger claim. So it seems to me that maybe the human rights conversation, which is largely an international law conversation, does have something to possibly add to the natural rights conversation that's happening at the domestic level, and to help support those arguments that are more for natural rights being more moderated than some of the literature would suggest. So again, I'm not saying that natural rights philosophies are better than utilitarian philosophies. All I was looking at was, what does human rights do? And even though initially my reaction was we shouldn't have human rights IP because it's bad, I'm thinking even if one does go down that road, it's possible that you could use that conversation to moderate what's being said about natural rights, natural property rights, in the intellectual property space. So that's what I'm working on. I welcome your thoughts, your pushback. Tell me what I missed, and if it makes sense, if it doesn't make sense.
So I just was wondering if you could add a little clarification on what you're thinking about as a domestic conversation about natural rights.
A domestic conversation about natural rights. So I think that the domestic conversation about natural rights, the way I see it, focuses on is there a natural right to intellectual property? So you hear the comment that there are people that believe that there's a natural right to intellectual property, and so because there's this natural right, you can justify the rights, and it doesn't matter whether or not the IP is doing any good for anybody. I think that the natural rights conversation is about that to some extent versus utilitarianism, or those who say, that the couple of scholars who will say, well, actually, no, let's use natural rights to have a more moderating influence. And so really, it's a question about intellectual property rights as natural rights, but really focused on the property angle. So if that's a clarification for you. Go ahead. You had a follow-up question.
I was still confused, but it could just be me, so I'll let someone else ask.
So I thought about this topic somewhat when I was writing Solar Creativity, and I had one of the last chapters looks at moral rights as potentially human rights, and so many of the sources that you talked about were things that I looked at. And I guess one of the things that I thought about or learned when I was doing the research was that in order for something, first of all, to be a natural right, or excuse me, a human right, it has to be pretty much applied uniformly. That would be a problem. Uniformly. And that would be a problem in the context of moral rights, at least, which is what I was looking at, because there isn't really a uniform application of that, as we heard from one of our earlier presentations even today, right? So I guess I wanted to ask you a little bit about that, and then I wanted to also suggest something that I thought about a lot when I was writing that chapter, which is that maybe it's not at least moral rights would not be human rights, but they would be normative rights. And there's a difference, I think, in terms of the acceptance between something that's normative, which could possibly change culturally, versus a human right that is pretty much, something that has more, I think, gravitas to it. Mm-hmm. So I just was wondering about your reaction to that, both the uniformity question, if you've encountered that at all in your research, and looking at IP really as more normative standards as opposed to actually human rights.
Okay, thank you. So on the question of uniformity, theoretically, the idea is that these rights are all equal and that they should just carry across. But in practice, people have said, in fact, there is not uniformity as you're suggesting. So it's really the theory and the practical application being two different things. So that definitely exists. And so I do acknowledge that. But I'm thinking about it more from a theoretical perspective in terms of our discussions about IP theories and how we rationalize intellectual property. So I do acknowledge that, practically speaking, that it might not be quite accurate. As for moral rights, I have to tell you that I've not delved into moral rights as they exist in law right now, because I think this conversation is still, there's a lot that still needs to be fleshed out in the human rights conversation, right? So some of the language in the Universal Declaration speaks about moral and material interests, okay? So maybe we're talking about moral rights, but maybe we're talking about something that's different from moral rights the way we understand it in the law, right? So we have moral rights for copyright. We don't have moral rights for patents, for instance. So you have a human right, but whether or not it's implemented in a particular country in a particular way is a different thing. So all to say that you could have a moral right as a human right, that might not be the same as a moral right as we understand it under our current law. And so it's not something that I've delved into at this stage, but I think it's a question that exists, right? So is that moral right the same thing? Should it be the same thing, right? So we talk about attribution and integrity. It might be that, it might be something else. So I don't have an answer for that, but it's a good question.
Thank you.
So your basic move seems to be, once we think about it, those natural rights as human rights rather than natural rights in the domestic context, we see that there are other countervailing interests which are indeed on the level of rights as well. And then we get what Europeans would call horizontal balancing, right? That's basically the logic of your argument. And then the question for me becomes, once we did that move, are we back to just good old economic analysis at this point? Like, do we have balancing?
Well, and so again, I mean, this is why I'm saying, to be very honest, I'm not a natural rights advocate by any stretch of the imagination. I'm not sure that the balancing that's done is better. But the only question I was asking is what is there that human rights does differently? And maybe it brings us closer to a sort of a utilitarian approach. That might be what it's doing at the end of the day. Thank you.
No, not necessarily. So
Okay.
what I was going to ask about, so what I was hearing, so if you're thinking about like intervening in the sort of IP theory and in terms of normative theory, it seems to me that there's other human flourishing theories that are more aligned with the human rights discourse and law, than either utilitarianism or natural rights theory, which I would term human flourishing, capabilities approach, Marcusson, a number of scholars in the IP field have sort of dabbled into that a little bit, and so I think that might be, I mean, I'm just guessing, but that seems like it would be a fruitful place for you to look and to think about, how turning to a human rights theory of IP, what it would look like. And there's people who are doing this in the property literature, sort of alternative social obligation theory, the Greg Alexander, that whole crew are thinking about different approaches to thinking about property law. And they're similarly looking to human flourishing type theories. I don't know that they've connected to human rights per se. Hanak, what's the guy? Yeah, so he's written a lot of interesting stuff that would be probably useful for this project. I mean, I think it sounds like a great project, but I do think it don't get steered into it lead where Oren's it doesn't necessarily steer you to utilitarian and economic analysis. It may very well steer you to different approaches.
I wanted somebody to say that. I wanted somebody to say that.
Thank you very much.